This is a really interesting and increasingly searched topic here online. What happens to my crypto when I go and die myself? What happens to my crypto when I pass away and go into the other side? Well, it's not just crypto, but obviously that's a huge topic that I want to talk about. All kinds of online assets and digital ecosphere that you need to pay attention to. Money could be lost. Everything that you worked for, boom, could disappear, and your wife, kids, whatever, may not get access to it. But there's this very specific law out there. Florida Statute Chapter 740, fiduciary access to digital assets. This is the law. It's been on the books since 2016, covers cryptocurrency, online, social media, email, online businesses, everything that's digital. And it creates a specific legal framework that either protects your estate or destroys it, depending entirely if you plan for it. And I got to tell you, I promise you, there ain't a whole lot of people out there doing estate planning. They're increasingly putting that in there. But here's the bottom line. 25 years I've been doing this. I learn something new every day, something that should be being incorporated into the estate planning that's doing, but it's not. But the law is this. The revised Uniform Fiduciary Asset to Digital Access says, oh my God, one more time. Revised Uniform Fiduciary Access to Digital Assets Act, commonly called RUFADA, RUFADAA, in 2016 is when it was passed. It's codified into 740 of Florida statutes. The central problem it tried to address is this, and that is when, poof, you often die yourself. How do you get access to all this stuff? And I promise you, these smarty pants legislators out there doing this thing, passing this law, have no idea how much the world has changed since 2026, a month ago, much less 2016. So I promise you that even though this law exists, its function today is going to be masked behind all kinds of new procedures within Coinbase and all these other access. But here's the bottom line. 740.002 describes a fiduciary, meaning a personal representative trustee, may access a person's digital assets only if the decedent or principal authorized such access. The word authorized is everything. Think about these wills that have been done out there since 2016 that do not include 740.002. The highest priority for everyone out there is to maintain a platform that has legacy contact. The new online stuff largely has it. Google, Apple, Facebook, all these financial accounts. You got to have that legacy contact. If no online tool exists, you got to have that in your estate planning documents. Within the terms of service, they do this. But I got to tell you this. I've issued subpoenas now to these online companies, whatever, Google, California. They don't care anymore. They ain't responding to the subpoenas. The crypto problem, which again came up largely after the statute was passed, is much, much worse. If you got crypto out there, if you got hidden accounts and you go and die yourself, your wife ain't getting that money. Your kids ain't getting that money unless you've left some crumbs for them to come after. What is a crumb? Crumb is a piece of paper largely, because some of this stuff is going to disappear behind passwords and digital authentication, and you ain't getting it. The kids ain't getting it. Wife ain't getting it. Here's the practical scenarios that I see and have seen. Dad dies. He's got a Coinbase account, $100,000 in it. The will says my kids get everything equally, but it doesn't include specific language out there for the digital stuff. So poof, that could be a nightmare trying to get a hold of, and you just may not get a hold of it. Everything you've dumped into Coinbase or digital stuff evaporates. Number two, Dad's got this Ledger hardware wallet. No one in the family knows what the PIN is. So that money that's sitting in there, that digital stuff, poof, it's gone. You ain't never seen it again. Another one that may be closer to home and maybe a little more realistic for a lot of people. Mom, dad, somebody's got some online business, little tiki-taki there, little Etsy, little whatever, a monetized YouTube channel. It's generating some income, but you die, boom, the revenue stream goes dark, and you don't even get access to it. The accounts are just up and terminated. So estate planning practitioners, listen to this. Look at that 740 and authorizing that specific contact into these kind of online digital ecosphere. But here's the litigation angle on this, which is going to be fun. Trustee, personal representative, again, that professional class over here knows that what they're dealing with is a crypto bro or an online bro. and they don't plan for that in the estate planning documents. And then the crypto bro goes and dies, or the mom that's monetizing all this online stuff, she all goes and dies herself. You got kids over here that can't get access to that. They're going to be looking at the fiduciaries, the professional class over here, and saying, why didn't you protect us? Why didn't you monetize dad's channel? Why didn't you get us access to mom's account? You didn't do it. There's liability. There's litigation.